Good afternoon, everyone, and thank you for joining us. I'm Christina Fox, the Chief Executive Officer of TechAlliance. As the Regional Innovation Center for Southwestern Ontario, TechAlliance is the place for dreamers, innovators, and world-changing ideas. We're focused on building a globally competitive innovation economy that enables entrepreneurship, spurs accelerated growth, attracts diverse and ambitious talent, and new companies. And we do this with you in mind. We consciously seek vital and valuable content for our tech founders across Southwestern Ontario, like today's webcast, the second in a two-part series focused on intellectual property. We know the incredible amount of thought, time, and work that is part of the creative process in actualizing a new product or innovation. Owning the IP protects your idea on that sometimes wild and complicated journey. Canada's IP strategy is designed to support innovation, stimulate growth, and create jobs across the innovation economy. And at TechAlliance, we want to ensure our businesses, creators, entrepreneurs, and innovators have access to the best possible IP resources through IP awareness, education and advice, strategic IP tools for growth, and IP legislation. We're committed to supporting entrepreneurs on their terms with the guidance they need most. And we're so pleased to be partnering again with the Canadian Intellectual Property Office. And we know that you'll find value in today's topic, inventing the next big thing, why patents matter. So before we get started with our keynote speaker, I just want to remind everybody that we are muted today. Feel free to add any questions to the Q&A feature located at the bottom of your screen. We happily will take questions towards the end of the webcast. Today's webcast will be recorded and available after the call, as well as some additional resources provided by the Canadian Intellectual Property Office. If you'd like to keep up with everything there is to know about Southwestern Ontario's innovation economy, we encourage you to sign up for our weekly newsletter. That link will be dropped in the bar. So now let me introduce today's speaker, Dumitru Olariu. Dumitru is an intellectual property advisor at the Canadian Intellectual Property Office, second-time speaker for us here at TechAlliance, and he has worked for more than 30 years with the Canadian Intellectual Property Office, an agency of innovation, science, and economic development Canada, first as a patent examiner and now as an intellectual property advisor. So before that, Dumitru worked for 6 years in the electronics industry. He has an educational background with a master's in science in electrical engineering and an MBA. Being immersed in the world of IP daily, Dumitru can capably answer all of your questions regarding best practices, where to access information and resources when looking to protect your inventions and innovations. So without further ado, I'm going to pass things over to Dumitru. Thanks so much for joining us, Dumitru.
Good afternoon. Thank you, Christina, for your kind introduction. And thank you all for your interest in intellectual property and the presentation today. Today, we'll talk about patents, why patents matter. And we'll go in further detail and comparing patents as well with other forms of intellectual property. The agenda is a quick overview of main types of intellectual property that you find in Canada. Then we will define patents and patentable inventions. We will go through a case study that will help us better understand what is in a real life when you try to patent an invention, considerations that you have when you go through all this process. Patents are very valuable assets, and we will talk about the value added by patents as well. And in the summary, we will review what we consider the most important things to consider when you start that process, and also further links to important resources that you may get more information about patenting. So intellectual property in general may be defined as creations of the mind. So depending on what you created based on an idea, if the creation is a brand, for example, you may get a trademark. A trademark is an identifier of products and services. And when you register a trademark, you may stop someone of using the same kind of identifier for similar like products and services. The protection lasts for 10 years and may be renewed indefinitely, and it's important to use it as such, as an identifier. Creations from the cultural field, literary, dramatic, musical, artistic creations, if original, they may be protected by copyright. That's another important type of intellectual property. And if you have copyright, you may stop someone of copying, producing, reproducing a particular work for a limited time. Trade secret is any kind of confidential information that may be kept secret, gives you a competitive advantage as well. So as long as you keep it secret, you have that kind of protection. You may stop someone of disclosing what is the subject matter of the trade secret. And maybe product related, a process, a machine, maybe business related, like a business plan, a list of customers, potential business opportunities, you name it. As long as it gives you a competitive advantage and may be kept secret, you have that kind of intellectual property protection. Industrial design, another important type of intellectual property we find in Canada, it deals with the visual aspect of a product, maybe configuration, pattern, ornament applied to a finished article. And once you apply and they get you a industrial design registered, you are protected for 15 years. So these are the main types of intellectual property. We'll talk more in detail about patents. A couple of things that are common to most types of intellectual property. They are limited in time. They are country by country. So, it's important to remember that some forms of intellectual property work in relation with others. And if you have a good management system of your intellectual property assets, you may increase the value of your business tremendously. So we'll talk more about patents. And I suggest that you look on the YouTube a short video that explains what is a patent, so you may look at your leisure. A patent is a grant of Government of Canada, actually, that in exchange for disclosing an invention, you have the legal right to stop someone of making, using, and selling the claimed invention. So what is a patentable invention? It's any new, useful, and inventive invention. The protection lasts up to 20 years from the filing of your patent application. And the right consists in your right for that period of time to stop others from making, using, or selling the claimed invention. So a patentable invention might be one of this: a process, a machine, a composition, a product, an improvement of all of this. They have to be new, useful, and inventive. We'll go in further detail on that. As examples, a process might be a process of making door locks. A machine would be a machine to manufacture door locks. A lubricant for door locks might be also a patentable invention. And the door lock itself, might be considered, if new, useful, and inventive, a patentable invention. Keep in mind that most patent applications are for improvements to existing inventions. So probably 90% of that. So let's go quickly to a case study to better understand how the process works. You may find on our website different case studies, and you also find for some of the case studies a video that he explains in brief the case studies. This case is a video on the case study called John Thompson. And I suggest that you go on the CIPO's website and click on the video and watch a summary of the case study. What John Thompson did, he bought glass recycling business from his uncle, and this business seemed to run smoothly. However, he found that sorting glass by color, it's quite expensive, time consuming. So he decided to change the glass sorting that was manual by automating this. And he searched the literature and he found that lasers might be used to sort glass by color. So he thought of a machine, a glass sorting machine, where laser will be used and the glasses will be sorted by color, then crushed and then recycled. That was his idea. So he built up a prototype, and that's quite important because you may say that you are ready to patent an invention when you already have a prototype, because you'll be able to, having a prototype, you'll be able to describe fully your invention. John Thompson actually went to his former college professor for advice. And he got very valuable advice. First, advice was to ensure that the invention is not already published. So he searched patent databases and other literature in order to see if there are similar patents already published. Keep in mind that he improved most probably on an existing machine, an existing technology. However, if this improvement made a difference, it's new, useful, and inventive, he can get a patent and patent protection for that. In the very beginning, it's quite important to keep the invention secret. That's the only form of protection you have at this stage. And the way to do it was, he was advised to get some information from the technology transfer lady with the college, and she advised her to have a non-disclosure agreement and other confidentiality agreements along the way before making the decision and actually filing a patent application. So in its case, let's see if the three patentability requirements were met. First, was John's invention new? Yes, he searched the literature and he found something that was unique. So he improved on a sorting machine using lasers. And its invention has to be new in the world. And for this, you should search extensively and see if it's really new in the world. It's useful because it gives an useful application. It's a sorting machine, separate glass, so that's quite obvious that it's useful. Non-obvious or inventive ingenuity, as it's called in the patent language, it's not so easy to define. Sometimes you have to look at what was the level of knowledge in the existing technology field and see if a person that would be of regular, I would say, or average knowledge in that particular field will consider John's invention inventive. So, you know, in many cases, it's quite natural. You see a simple invention, a simple improvement, and you ask yourself, oh, it's very simple. I could have done this myself, but it's not so easy. After the fact, you might say that. However, if an invention is new, though it's a small improvement, and if it's followed by commercial success, it has that scintilla of invention. So that ideal person in that in the field of technology of the invention has to say, oh, why I haven't thought myself of that before. So that would be like there is inventive ingenuity. So in order to make sure that the invention was not already disclosed and old, so it was new, John was advised to search different patent databases. You have a list of databases here. You also have others like European patent databases, Japanese abstracts, even Chinese patent database that is translated into English. And I advise you, because they have major databases beside Canadian and United States database. So it's advisable to search that before even thinking of developing an invention and later on patenting an invention as well. The invention has to be secret. That's a reminder. That's what John did as a first step. It's a good advice actually to keep a record of the invention, dated on what stages you went through and at what time you developed. Though whoever files first a patent application gets the patent. So several words about patenting in different countries. There is that misconception that you may get an international patent. Actually, what it's possible is to go in each country and have patent rights in several countries, or use a so-called patent cooperation treaty application, and filing just one application in one language with one office, and designate as many countries are members of the PCT application. And in the first stage, it goes through 2 stages actually, international stages, and then it will fall in different country patent offices. So it's quite possible to start the process. It's very convenient because you don't have to deal with many offices at the same time. So you deal with just one office in one language, and you pay just one set of fees, and you may actually get a good idea on where you should go to obtain a patent in which country. The scope of the patents is not absolute. What it means is that you get that right to stop someone of using what you claimed as your invention. However, if you develop on someone else's patented invention and this patent is still in force, you don't have the right to work your improvement, though you obtain the patent for your improvement. So you have to get that permission. In most cases, the owner of the patent of the initial invention and the owner of the patent for the improvement invention, they exchange licenses. So they allow each other permission so they can both take advantage of an improved invention. Patenting is probably the most costly form of intellectual property. And here you have an idea about this slide shows how much might cost you in terms of government fees. So if you pay the regular fees, it's 400 for filing, 800 for requesting an examination, and 300 over registration. These are the front-end fees. if you qualify as a small entity, like a university or a business with less than 50 employees, 50, then you may get a reduction of those fees. So 50% reduction, you will pay front-end fees if you do a little bit of math, just $750. The process is quite complex and we'll go into detail on this. So it's advisable to hire an IP agent, registered patent agent or lawyer to take care of the process. Theoretically, you may do it yourself if you're a private inventor, if you don't sell your patenting rights to someone else, you may do it yourself. There is a tutorial, actually, patent tutorial on our website helping you on how to go through the process yourself. So it takes time to get the patent. The patent term is from the filing date up to 20 years. And you have to pay maintenance fees as well. You have to consider that in budgeting for obtaining and maintaining and enforce a patent. I said that your invention has to be new in the world at the moment of filing. However, in Canada, in the United States as well, they work a little bit differently, but there is 1 year grace period that you may take advantage of it. It's not advisable to use it. Other legislation don't have it. So keep in mind that you may lose your patent rights elsewhere. So it's important to consult an IP professional, even from early stages, because they may give you, they have a very good feeling actually by looking at what you have. If you have a good case, if your invention might be patentable, they may come with an estimation of how much it will cost you. So you may have like a filing strategy on patenting country by country internationally. So it's important to understand or to prepare, to do the homework when you visit such an agent. I advise you to go on our website. There is a so-called guide to patents, and it has a special chapter, how to assist your patent agent. It gives you some tips on to do a preliminary basic search, to understand other types of IP that might help you with business success based on your invention, to consider what countries you'll be protected. All this are spelled out in a guide to patents. What an intellectual property specialist does, actually, it gives you a patentably searching opinion. They have to do a professional patent search in order to give you legal advice on your chances to get the patent, and also explaining you how strong your patent claim seems to be. They can also search trademarks that you are considering trademarks for your invention and give you a legal opinion on that. Then they start by drafting, and based on the description that you gave to the agent or lawyer, they start drafting and preparing, writing actually the application, a full teaching of your invention. That's how, or that's the deal, that you'll get the patent rights if you give the full teaching. And in this patent document, you should fully describe how your invention is made. If it's a machine, all the components there, and point to what you actually invented, the improvement that you made. If it's a process, you describe the steps. It's a detailed document. You give enough teaching, not more than it's necessary for someone who is familiar with the field of technology to reproduce the invention. That's what the law says about the completeness of a patent application in terms of disclosing the invention. And the end of this document, patent application document, is a set of claims. It's quite important to draft them properly and cover your invention and claim it properly, in the sense that you'll claim not more, not less, that you really invented. You are helped if you decide to go yourself, not with the help of a IP agent or professional. You'll be helped by our patent examiners on how to adjust, modify the claims to proper claim your invention. However, keep in mind that if you disclose more and claim less, it's something that you give away. So your protection, it's less than it's supposed to be. By having the help of a registered patent agent or lawyer, you'll be able to avoid this kind of mistake. The patent application is then examined, prosecuted, as we say, processed simply, and the patent will be righted after. So for all this work, professional work, depending on the complexity of the invention, but you should look at a budget of $10,000 actually. So other considerations, you notice that the patents are very expensive. So you have to make, let's say, or answer this question. Is it worth it, patenting, time-wise, money-wise? Time-wise means, is it a long lasting, or it seems to be a long-term invention? Then probably you'll consider patenting. But if not, you'll decide otherwise. You have that option, and actually a lot of companies are using it. They don't patent. They simply disclose the invention. So they put everyone on the same level playing field, because you disclosed it, nobody else can patent it. It's no longer new. So you stop others of obtaining a patent and go after you with their patent rights to stop making, using, or selling the invention. You may also consider trade secret, if it's worth keeping it secret or not. Trade secret as a form of intellectual property protection means that you have to take steps to keep it confidential. There is some effort, money that is involved here. So, but you have that option through non-disclosure and confidentiality agreements. So let's talk a little bit about value added by patents. It's patents right is a valuable business intellectual property asset. It should show in the business books and the assets of the physical assets of a business. But value added by patents is also revenue source, competitive advantage, attracting investors. Let's go in further detail on that. So a lot of investors are quite keen in analyzing your business if they want to inject money in your business, to say if you take proper care of intellectual property assets of your business, in this case for the patents. And they are quite familiar on the value of the patents, who are the experts who can help them decide how valuable a form of intellectual property is. So they have a good indication how much money they may put in your business, taking in consideration intellectual property. Patents are like patent rights and other intellectual property rights is like a monopoly. You get market exclusivity, and you simply can stop the competition of using, selling, and manufacturing what is your claimed invention for up to 20 years. It's a very powerful intellectual property right, and it's, though not too many patents are followed by commercial success. However, if you get the patent and keep it alive for so many years, you might take advantage of market exclusivity. You may make money with them by exploiting the actual invention, having that freedom to operate the invention, but you may also license to others and make money by collecting royalties. Or if you decide that it's very hard, or your business strategy is not in making, using, and selling the patent invention, why not selling the patent rights to any potential buyers? Actually, there are some reputable companies as IBM. They are more involved with research and development, and they create a lot of patentable inventions. They obtain patents. However, they are in the business in selling a lot of their patents, or giving licenses to people who are able to put them better for a market. So usually what is considered a valuable patent is one that has the applicability in a variety of fields. So a lot of inventions are found in different, let's say, machines in different fields. So that is considered a valuable invention. You may think of processes that are found in cars. If you have a valuable patent dealing with a computer implemented invention in all this electronics, you may get a very, very valuable patent this way. So, patents valuable are those for different implementations and variations. Keep in mind, that's why you hire a registered patent agent or lawyer, because they are able to claim properly all these implementations and variations of your inventions, and you'll have the proper protection. So let's talk a bit about value of patents with some examples. One is the ProSlide. ProSlide is a trademark of a product. It's a sliding device that it's used in water parks. ProSlide was a very successful product. It gives to the company a very good market value, and they noticed the potential to obtain good profit by patenting in many countries. So they started with an impressive, actually, intellectual property portfolio with patents. So they were able to use properly this form of intellectual property protection. They started with early on with the development, and they kept secret the invention. Then they studied the market, and this I would like to emphasize here. It's good to start with a patent search to see what's there when you create an invention. However, a good question is it a market for my invention? So you have to answer that question in order to put money, time, and effort to develop a prototype and later on to obtain a patent. So do a market search as well. And you don't have to fully disclose your invention. You may describe the invention in general terms, as long as you not give full teaching of your invention for someone who works in the same field of the invention, then it's not considered public disclosure. So your invention will still be confidential. However, you'll be able to test the market somehow if there is some sort of opening for this kind of invention that you have on your mind. An example on how powerful this intellectual property right might be, if you face with the competition as this company in United States, in the state of Michigan actually faced, Target Sports invented that synthetic turf, and another company, American company, they decided to ignore the patent rights and infringe in Target Sports patent. So usually when there is an infringement case, you get compensation for the damages that your business suffers because your competition infringed in your patent and got a share of the market and so on. But in this case, AstroTurf was asked, the infringer was asked to pay 3 times the damages, so because they consider it was an willful infringement of the patent rights. So the system works, it makes sound. Actually, when someone is infringing on your patent, in the very beginning, you may consider a good sign because it's something that it's of interest to others. There are some statistics, they say that 10% of all patents are followed by commercial success. So if you have success, you have to expect that people will try to use your invention somehow. And in some cases, they will infringe in your patent. But you have the possibility to negotiate a deal, to make them pay a license if they are not direct competitors. So there are different options that you might consider. Another case study of interest is that of Lee Valley, a famous Canadian company that manufactures tools for gardening, landscaping, woodworking tools, and they develop lots of tools. They come with new tools on a regular basis, but they consider how long this tool might be used, how valuable would be, how much the patenting for the tool will cost. So they have in place a very good management system of their intellectual property asset, and they go only with what would be like most profitable or the most promising invention that will justify the cost of patenting. So in summary, I hope you got the main message that the patents are for inventions that are new, useful, and non-obvious. After obtaining the patent right, you have a maximum protection for up to 20 years following the filing date. The inventions might be a small improvement as well. Might be an invention that opens the art or the field of technology. However, that's very rare. Most of the improvements, as I said, 90% of them actually, according to some statistics, are improvement on earlier inventions. However, they might be very valuable, and we went through that. The rights might be acquired by country. It makes sense to go without using international patent cooperation treaty applications if you are just looking for let's say United States, Canada, and UK, so one language, probably 3 different patent offices, but easy to manage. But if you're looking for more countries, you should consider PCT, Patent Cooperation Treaty. So keep in mind that you get a powerful monopoly because you'll have exclusive right to make, use, and sell the claimed invention. You'll get that market exclusivity, as I mentioned, a revenue source. You may attract investors. The IP asset is a valuable asset of your business, and you secure a competitive advantage. Many businesses are very successful because they know how to manage their patent portfolio, intellectual property portfolio in general. So here you have information about the 2 organizations that worked for this presentation. One is the Intellectual Property Institute of Canada. That's the Association of Registered Patent and Trademark Agents and Lawyers. And the one is the government organization, Canadian Intellectual Property Office I work with. And I thank you very much for your attention.
Thanks, Dumitru. I wanted to start off our Q&A session carrying on from sort of the last comment that you made, and that was successful entrepreneurs manage their patent portfolio. And so it's a really nice broad statement of, how do you do this well? To that end, can you share with us some of the common pitfalls or mistakes that entrepreneurs do make in the patenting process? And you've given some really good case studies today, but are there some things, if you could say, do this, but don't do this, and don't do this, and don't do this? Would there be a couple of different things that you can share with some founders who have already undertaken a patent process and could be on to another one, or some who are about to embark on that process? So common mistakes.
Common mistakes, inventors don't keep, and it's very useful to keep like a diary of what they created at a certain time, a timeline of what they created, and they should not rush with the patenting. They should create a prototype. And it's better to learn from what the others did before, to search the patent literature, the technical literature. So you develop your invention, and they get very useful actually hints on how to improve your new invention and tweak it out, and come with a successful invention by learning from what the others did. So that's what I would suggest. Do not rush, but in the meantime, keep in mind that the patent system is a first-to-file system. Once you created a prototype, patenting cost makes sense to you for the potential business success that might bring along, go ahead.
Okay. I remember in the first part of our 2-part series, we had talked about how to find a good patent agent and an attorney. That question's been asked again in this chat, probably by a new participant. Could you give us a few tips on going about finding a good patent agent or a good patent attorney?
Actually, we developed a paper that helps you like do your homework on shopping for the right patent agents or trademark agent as well, and how much it would cost. So most of the patent agents or lawyers, they can easily handle mechanical inventions. However, when you have an inventions in biotech or computer implemented inventions where a lot of software, source code, and other stuff like that is involved, it's better to ask if they have expertise in this kind of over specialized field. And then it's good practice to ask for a so-called free of charge interview. Most of them they will give you. If they are not too busy, half an hour you will get it for free. And if you do the homework correctly, as I mentioned in my invention, they will have a good sense if you have a good case. And you may learn from that half hour, and if it's worth hiring this patent agent or lawyer. And keep in mind, I mentioned that 2 to 8 years takes to get your patent. So it's a long-term relationship that you establish with your agent. And the good communication is important from very beginning and all along the process.
Okay, there was, you had made a couple of notes in your presentation about applicability. So if valuable patents have applicability in a variety of fields or implementations, how does one ensure that their original patent covers new applications in the future? Can it? Or, you know, is it an ongoing process?
Here, actually, that's an important role that a specialist like a patent agent or lawyer will play. Mm-hmm. Because based on your description of what you invented, they're able to claim properly the main, all embodiments of your invention and obvious variation of your invention. So the claim will cover any, let's say, evident or self-evident variations of your inventions and all embodiments. That's quite important. And there are some few inventions like that that open the art, as I mentioned, open the field of technology, and all the others coming after that, they improve on yours. So they have to ask your permission if you have the luck to be the first one getting that initial patent.
Okay. Another question here, is software patenting sufficiently defensible? Is it worth pursuing this as a startup company? That's a great question.
Oh, would you please repeat?
Is software patenting sufficiently defensible? Is it worth pursuing this as a startup company?
Yeah, you know, the legislation is changing in how we assess the patentability of the software people call inventions. We call them computer implemented inventions. Traditionally, the software has to be interlinked with hardware, and the invention has to point to the hardware, not the software. Software traditionally is covered by copyright. The source code, usually trade secret, and the program, the computer program by copyright. However, the legislation is not settled in the sense that there are many cases. One that is famous would be like a one-click patent obtained by Amazon. So we changed and adapted the way we examine this kind of patent applications, and actually allow, I would say, differently claims for software or computer implemented inventions. So you should not be afraid when you have and inventions like that. Actually, there are so many players having many inventions, like companies like Apple's, even Uber. They have plenty of computer implemented inventions patented.
Okay. Another question from the audience: why are patents often written in vague legal terms versus clear engineering descriptions? And as an engineer and a patent expert, Dumitru, I wonder if you can share your thoughts on that.
Yeah, I was a patent examiner, as I mentioned. So in the very beginning was very intriguing for me why it would be that. But actually, if you look at a patent document and the claims, they look like legalese. However, if you go back to the description, the specification, every term used in the claim has to be supported in the document. So you'll better understand the claim if you'll go back to the specification, drawings, description of the embodiments, and so on, and you'll understand exactly what is claimed. Okay. So you might say that the claims are, let's say, the terms, and the explanation of the terms or the dictionary is in the rest of the patent document.
Okay, and I think we'll go with our final question here. taking a look at the time as well. Oh, there might be two questions actually here. Oh, let's go with this one first, and then I'll close with the last question. Is provisional patent application worthwhile?
Actually, it's very popular to start with, so that's a good sign that a lot of people are using. Even patent agents and lawyers advise you, depending on your own situation, why not starting with a provisional patent application in the United States? You may gain time. However, the time is clicking fast, so you have to make a decision within 1 year after filing the provisional patent application and file a non-provisional patent application based on the provisional. So that's sometimes it goes so fast, 1 year, and you'll not be able to enforce or consider your provisional patent application a regular pending patent application that will be transformed in a patent and to get the patent right. So it's no protection.
Okay. So for example, if you know you're in the last mile of your invention and you want to use a provisional patent as a defensive mode to I guess, buy yourself more time, would you recommend doing that just so that you can be clear that nobody else files a patent while you're toward the end of or ready to file your own patent?
Yeah, you might strongly consider that. You're not ready yet to file a full-fledged patent application. You want to take advantage of what you developed so far. So you file a provisional, you might improve, after filing the provisional, you might improve your invention and decide probably you don't need to transform the provisional and you file another provisional or a full-fledged non-provisional patent application. It's quite possible.
Okay. And so then our last question, how do I decide what form of IP protection to use as I'm preparing my patent and awaiting a response? So perhaps some of the same question, but are there any other ways or any other forms of IP protection to use as you're preparing your patent besides a provisional patent, as an example?
Actually, if you're looking for commercializing your invention, you should first consider what brand or what name for your invention will do. And some inventions even asked by businesses. I mean, you'll not go through the consumers. You'll still probably be interested in having a brand name for that. It's quite popular these days to sell components, for example, auto components to auto manufacturers, and actually the component itself has a brand. So plus it's a patentable invention. It might be the case. So you should look at all forms of intellectual property and see what makes sense to you. Industrial designs as well. It's considered a neglected form of intellectual property. However, you may make a lot of profit and increase the sales by using this kind of protection as well.
Okay. Well, that brings us almost to the close of this afternoon. I want to offer my thanks to you again, Dumitru, for joining us. Intellectual property advisor from the Canadian Intellectual Property Office. It's been great to spend time with you on 2 occasions and supporting entrepreneurs, founders, inventors who are curious and interested about really moving forward with intellectual property and that kind of protection. Offering resources and sharing with us how to best access resources or access folks like yourself to have some of these additional, more detailed questions. Of course, we always encourage those on the line to connect in with our venture growth services, and certainly interested in having folks connect directly with you and your team. So this is indispensable knowledge for the tech industry, particularly in the intangible economy, where the protection of ideas is taken very, very seriously, and the opportunity and the potential for commercializing IP is right here and available. With the kind of information we're sharing today and through our team, this is the kind of information that is really valuable to founders. So again, thank you for your time and your preparation for this, Dumitru.
Oh, thank you, Christina. Thank you all for your interest.
You bet. And I'm just going to use a moment to share a few things that we've got coming up on the horizon or down the pipe. We've got an upcoming experience with both fierce and fantastic Jody Kovitz, who's the founder of Move the Dial. She and I are going to go live on Instagram on October 22nd. I can't wait for the conversation. We're also hosting a masterclass with Tyler Bryden related to fascinating areas of growth within artificial intelligence. So we invite those of us who are on the webcast today to join us on those dates coming up. And that's it for us today. Thank you everyone for joining us. Have an incredible day. Be well and stay safe. Take good care.